They're trying to suppress the story.
Make me do it.
I don't want to do it. He doesn't have to go up the steps. I'm just gonna say it. It wasn't leaked to me. I earned that. I paid for that funeral. I paid for that. It's my right. You ain't taking that from me.
Calm down.
If you don't want to say nothing, that's your bet. But don't say I'm leaking anything. I paid that bill. Sent my daughter to college to get an education. She came back in the box, and I can speak on that.
This day of court is not just for him, it's for everybody.
Yo, what's up? It's me, Neeks with the Peaks. We're gonna see about those motions in the oceans of orders and warrants in the seas of Idaho County. We're gonna go over the order for the court to reconsider the time for a speedy trial, which the prosecution turned in, even though that's typically kind of something that seems like it would be turned in by defense attorneys, and typically, well, yeah, that's kind of the case, which was a part of defense's argument in dispute of it. I read that this was some big conspiracy and everybody was crazy thinking something was actually gonna be filed, boom, in their face. Okay, not gonna bullshit, right? I was actually totally prepped to tell the public that it's kind of stupid to presume that every and any person should have an alibi if they are in fact innocent, because, newsflash, that's dumb. Not to mention that most people's alibis typically wouldn't be believed because, well, they're at home, like, eating dinner with their families and shit, and their families be all like, yeah, mom, dad was here.
That's a pretty exciting story. What's next? Lies on ice?
That is my way of saying that typically people's alibis won't be believed anyway, because a lot of the times the most common alibis are also, unfortunately, those that are easily made up in the case of liars.
Significant developments surrounding the legal proceedings of Bryan C. Kohberger, the defendant has made a decisive move by filing a notice through his attorney. The crux of his defense lies in the establishment of an alibi, a line of proof aimed at demonstrating that he could not have committed the crime in question due to being present elsewhere when it occurred. It should be noted that the mere denial of charges does not constitute an alibi. However, Kohberger's defense strategy takes shape as soon as he presents evidence supporting his claim of being in a different location than the site of the alleged crime. In light of this, his legal team is actively engaged in investigating and preparing his case, with a particular focus on gathering evidence that substantiates his presence elsewhere during the relevant timeframe. To fortify their arguments, they anticipate utilizing various strategies, including cross-examining witnesses presented by the state and introducing expert witnesses to testify on Kohberger's behalf. This calculated and determined approach aims to challenge the prosecution's case and shed light on an alternative narrative surrounding the events in question. The defense's masterstroke in using the state's own witnesses to establish the innocence of their client is nothing short of remarkable. It injects a breathtaking element of intrigue and astonishment into the ongoing legal proceedings. By skillfully employing cross-examination techniques, the defense aims to extract vital information from the prosecution's witnesses that could directly support their alibi defense.
Back in time before the alibi was placed, and talk about the motion to reconsider the order staying the time for speedy trial. Okay, now let me tell you, when I was first, I'm reading this before I read the defense's response to this, and I'm squinting my eyes so hard I probably have some new Idaho for murder wrinkles on my forehead, because this case is so whack sometimes. Let's just hit this ending for a moment. The defense pops off. It is particularly ridiculous that the state claims the public has some stake in forcing Mr. Kohberger to either abandon his constitutional right to defend himself or permit this case to carry on indefinitely as the state wishes. Either the public wants it in trial in October or it does not. The state's position on the waiver of speedy trial is its own, they stated. If the public is to take any interest in this matter at all, it should be to wonder at the cavalier attitude the government has towards one of the fundamental rights secured to our citizens. So essentially, that lets you know that the prosecution's attempt here was to say that it was none or all, meaning that you can't ask for an additional fucking 30 days to defend yourself. Sorry, buddy, but you can. And it doesn't shit on your right, because you can't partially have the right to a speedy trial. You either fucking gotta speedy trial or you didn't. Now, that was either the fault of your attorney or the prosecuting attorney. There is no in between. Each and every order, whenever these issues are asked by the leading judges in the Supreme Court, they will ask each and every time that the trial was delayed. That includes pretrial proceedings. That's not just the trial. It is from the date of incarceration or the date that the indictment was filed. Now, when asked on appeal, when asked in the Supreme Court, what they will do is decide who asked for each delay. Was this delay added for the prosecution or was it for the defending attorney in the case? Defense team, DA, or prosecution. There is no in between. Each one will be allotted. Was it in the aid of the defense attorney? And did it benefit the defendant? That is the question. Now, obviously, this would benefit the defendant. However, it annoyed me in the first place that they conceded so easily to this being taken off of Bryan's speedy trial, because I'd have argued that it shouldn't, considering originally they should have been allotted this time anyway. And that, I think, is what the prosecution is showing their hand with in a ridiculous motion to deny a defendant their constitutional right to fucking defend themselves. Good job, Leta. You're looking great.
Prosecuting attorney is making a mistake by saying that when Bryan asks for more time, it means he's giving up part of his right to a speedy trial. But that's not true. Bryan has the right to ask for more time to prepare his defense, and it doesn't mean he's giving up his overall right to a speedy trial. In fact, the law has a way to handle this situation. When a defendant asks for more time, that extra time is not counted against the speedy trial clock. It's like a special rule that says this extra time doesn't count because it's necessary for the defendant to prepare their case properly. So, even if Bryan gets these extensions, it doesn't mean he's giving up his right to defend himself.
That always is, of course, going to be concerning in whether someone got a fair trial or not. So defense attorneys are typically, in a criminal case, going to always be granted more time. Time off the speedy trial clock for prosecutors in the case that a defense attorney has asked for it and a defendant has agreed to count that time on themselves and then be denied that right is to be denied the constitutional right to defend oneself. Now, this is very important and monumentally bad. Supreme Court cases, time and time again, have decided how the speedy trial clock works. And typically for defense attorneys to ask for more time is like a gift to the prosecution. It's like owing someone a bunch of money, but they're going to be out of town on the days that you owe it. So you have some more time to come up with it. Meaning the prosecution gets a little bit more time to work on their legal case against the defendant while also having the same timer on the amount of time to do so. So it's like a free 30 days for the prosecution. And for defense, it's a constitutional right to be able to defend oneself. If that takes an extra 30 days, you get an extra 30 days. So to deny a defendant extra time to prepare their defense that is not even clocked off of the prosecution's time to prepare that case is absurd, nasty, illegal, and unethical. Things that shouldn't have happened to defendants have been decided in previous cases, which have now become what we use as case law to show a court a matter that it's already been sort of decided how this works, right? So legit, when the defense answers to the state's motion to undo the staying of the prosecution during time that the defense has specified they need for something that is funda-fucking-mental in someone's innocence or their guilt, which is the integrity of the indictment for which they have been incarcerated. All right, and not only that, but every constitutional right to dismiss from the state of Idaho includes the clause and disclaimer that it cannot be time which the defendant has specifically asked and signed off for.
On July 14, 2023, a temporary order regarding return of evidentiary items pending hearing was issued by the district court. There is a handwritten note expressing the court's concern about the transport of certain items. In an update released on July 25, 2023, the hearing, which was expected to take place, has now been canceled. This sudden change, announced just 2 days ago, has sparked curiosity about the reasons behind it and how it may affect the proceedings. We will closely monitor the situation and provide further updates as they become available. According to the state's motion to temporarily seal pending hearing, filed on July 4, 2023, and confirmed by the district judge, there is an order in place regarding the return of evidentiary items. The court may have concerns about the security and confidentiality of evidentiary items during transport due to several reasons. 1. Protection of sensitive information. Evidentiary items may contain sensitive information, such as personal data, confidential business information, or details related to ongoing investigations. The court may want to ensure that the transportation process minimizes the risk of unauthorized access or disclosure of such information. 2. Prevention of tampering or alteration. The court may be concerned about the possibility of tampering or alteration of evidentiary items during transport. It is important to maintain the integrity of the evidence to ensure its reliability and authenticity. Proper security measures can help prevent unauthorized individuals from tampering with or manipulating the items. 3. Mitigation of the risk of theft or loss. Evidentiary items may have significant value or importance to the case. The court may want to minimize the risk of theft, loss, or damage during transportation to ensure the availability of the evidence for court proceedings. This can include implementing secure handling procedures, tracking mechanisms, and ensuring the presence of authorized personnel throughout the transportation process. 4. Safeguarding against unauthorized disclosure. The court may want to protect against unauthorized disclosure of evidentiary items. This could involve restricting access to only authorized personnel who have a legitimate need to handle or transport the items. Confidentiality measures, such as sealed packaging or secure storage containers, may also be employed to prevent accidental or intentional disclosure. 5. Compliance with privacy laws and regulations. The court may consider privacy laws and regulations when it comes to the transport of evidentiary items. Certain items may contain personally identifiable information or other legally protected data that requires adherence to specific privacy requirements. As a side note, it is worth considering the theory that the agency responsible for certain operations may have been the owners of the house in question. This theory raises questions about the connection between the murders and the statutes, which aim to protect ongoing investigations, confidential informants, and the identities of law enforcement officers or operatives, while ensuring confidentiality and safeguarding lives. This speculation aligns with the notion that the removal of items from this particular house appears to deviate from what is typically expected of a residence occupied by college students.